Hey YouTube family, it's Humberto from GrayLaw TV. 2020, lots of immigration changes. I'm going to talk about 3 that you need to know about. Number 1, fee increases. Fees are going up substantially, folks. You better get the applications in. Number 2, public charge. You've probably heard of this. I'm going to break it down, make it very simple. And number 3, denaturalization. The Trump administration has set up an office to try to take away citizenship. So we're going to talk about these. Let's go one by one. Fee increases. So fees are going up substantially. I'm going to go through some of the forms that fees are going up, and you might want to get your applications in, folks. First, the I-130. This is a family petition. This is where you're filing for a family member. Current fee is $535. It's going up to $555. I-131. This is a travel permit that's issued in connection with your adjustment of status. Currently, it is $375. Proposed fee, $585. That's going up substantially. I-751, we have many segments on the I-751. This is where you're filing through marriage to remove the conditions of your marriage case. Currently, it's $595. That's going up to $760. I-765, again, this is an application for a work permit. You file this also in connection with your adjustment application. That fee currently is $410. That's going up to $490. N-400 application for citizenship. This is really big. It hasn't increased yet, but it's going to increase soon, so you might want to get those applications in. And by the way, we have an election coming up in November, very important election. So they may fast track citizenship applications, which gives you another reason to apply for citizenship immediately. That fee is going up substantially. Currently, $725. It's going up to $1,170. We've already seen on the non-immigrant visa end fees going up substantially. Premium processing was $1410. It's going to go up, folks. It's going up to $1440. It has already gone up to $1440, as a matter of fact. Sorry. So that fee has already increased. So we're going to see new fee increases. You might want to get those applications in immediately. Number 2, let's talk a little bit about denaturalization. So you've gotten the green card, you've waited 5 years, and you've applied for citizenship. Years have gone by, and all of a sudden, ICE knocks at your door, and they say, we are arresting you, taking you in, and we are starting a civil process to take your citizenship away. The Trump administration has just ramped up a new office to conduct investigations on individuals who may have committed fraud, misrepresentation, or crimes and deportation that weren't disclosed at the time the individual got the green card and subsequently became a citizen. These are grounds to denaturalize you. Don't panic, okay? Everything's going to be okay. There's not many cases right now, currently, but there is an indication that, they're going forward on this. The standard, what's the legal standard? What do they need to do? How can they take your citizenship away? They only need to show that you were not eligible to get a green card and then subsequently become a citizen, again, because of fraud. I'll give you an example. Let's say that you applied for your nephew abroad, submitted a fake birth certificate. That individually subsequently came to the U.S., got a green card, became a U.S. citizen, and they found out, that they were not actually related, and the beneficiary, the nephew, shouldn't have gotten the green card. Well, they can commence a civil case against that individual. There have been cases where even the beneficiary who got the green card through the uncle didn't know, what was going on. They were very young. They actually thought that this was their parent. And the civil case, what happened was they brought them in and they had them take DNA test. And it showed that the petitioner, purported father, was not the actual father. USCIS was successful in denaturalizing that individual. There's other cases where there was an asylum that was filed fraudulently under a different name. The individual was deported. That information never got in the system. Subsequently, the individual got a green card, let's say through marriage, through the spouse, legitimately. Individual went on to get a green card, subsequently became a citizen, and again, once that information in the database got into the system, and under this new office, they found that the individual was not entitled to the green card or had been deported previously, so would not have been entitled to the green card. They commenced naturalization proceedings. So again, it's not all bad news. It's very difficult for these cases, since they're cases of first impression. They will be litigated. So, the denaturalization will occur. Lawyers will file suits in federal court. There has to be, I believe, a more stringent standard to take your citizenship away. But that's happening, folks, so I just want you to be aware of that. Public charge. So public charge took effect February 24th, 2020. What is public charge? Public charge means that it's likely that you're going to become a public charge. You're going to be reliant on public assistance. What is public assistance? It's anything that's free. I'm going to make it real simple, folks. It's anything that's free that you get from the government, food stamps, Medicaid in California. It's different in other states. But anything that's free, that's given by the government, you have to be careful, because what they look at is in a 12-month aggregate period over a 3-year period. If you were on public assistance, then that's going to be a negative factor in your application. Now, how does this work? So it is a balancing of positive factors versus negative factors, okay? And what they look at, the factors that they look at age, they look at health, family status, assets, they look at resources, they look at education, they look at work history, whether or not you've been working. So let's say you're elderly, you've never worked in your life. That's a negative factor. Positive factor could be a supporting affiant. So if you have a family member that can provide what's called the affidavit of support and show that they make $26,663 for a family of 3, that would be sufficient, and that would be a positive factor that they will weigh in the application. So what they do is they do a balancing, right? On the high end, if you can show that your affiant makes $53,325 and has a family of 3, then that's a very strong positive factor. So what they're going to do is they're going to weigh, and it's discretion. So you want to have more positive factors than negative factors. You can plan. You can have a very strong affiant that comes in and provides what's called the affidavit of support. There is a new form. It's the I-944 that has to be submitted in connection with your adjustment application. So again, the public charge rule applies to individuals who want to become permanent residents, either through family or employment-based petitions. You have to show that it's unlikely that you will become a public charge, and you want to make sure that you have your ducks in a row. Again, I hate to be gloom and doom, so I'm going to give you one positive factor going away. That is, you can also post a bond of $8,100. That will satisfy the requirement that you will not be likely to become a public charge. It's a bond. Those are going to be fleshed out here recently in the future, but Again, you can overcome the public charge rule by being smart and planning. Thanks for watching GrayLaw TV. Click below, like and subscribe, and press the notification button. You can get our content, a lot more coming in 2020.